on the CINA 102.3 app at CINAFM.com, on TuneIn, on Smart Speaker, and at 102.3 FM. CINA Radio, every device, everywhere. The following program does not necessarily reflect the opinions of the management, staff, or advertisers of CINA Radio.
Joumana Kayrouz. You've seen her images on giant billboards across the metro. Joumana Kayrouz. You've seen her images on buses across the city. Now get to know Joumana Kayrouz.
The war broke out in my home country, Lebanon. I was 11 years old, and I saw a lot of bloodshed and inequality and poverty. You can't grow up in an environment like that and not be affected by it and not want to make a difference. I graduated from Yale University with a master's in ethics. I speak 4 languages. It has always been innate in me fighting for the underdog and trying to do whatever it is I can to make a difference in the world.
Let Joumana Kayrouz protect your rights. Call the law offices of Joumana Kayrouz at 1-866-YOUR-RIGHTS extension 100 or visit yourrights.com.
أيضا هناك استشارات مجانية تقدم بهذه الاختصاصات في مكاتب المحامية جومانا كيروز، ورقم المكتب هو 248-557-3645. تحياتنا لكم جومانا، مساء الخير.
مساء الخير رامي، كيفك اليوم؟
الحمد لله، نسأل عنك إن شاء الله تمام.
كتر خير الله، شو هالنهار الجميل. خير لكل المستمعين. ليبر داي ويكند. ومساء الخير لضيفتنا لليوم محامية ماريا بانشينكو. ماريا, good afternoon.
Good afternoon. How are you doing today?
I am good. How are you doing?
I'm doing good.
That's
Hanging
good.
in there.
Very good. Very good. I was saying that this is a gorgeous day today, and happy Labor Day weekend to you.
Yes, it is beautiful.
And happy and safe Labor Day to everybody as well. Today, Maria, we will be talking about family law and about criminal law, mostly about criminal law. We're going to talk again about what we call malicious use of a telecommunication device. We're seeing a rise in these filings by prosecutors and a demand on the part of people to file against each other these claims. Telephone harassment, computer harassment, maybe cease and desist letters, PPOs. We're going to talk about that in great detail today. But before we start talking about that, just a couple of things having to do with family law that I'd like to discuss with our listeners. We had an interesting call from a gentleman whose wife is, in the process of divorcing him. So it is pending in court, and he does not want to get divorced. And so he has been fighting this divorce, not up to court or not cooperating because he does not want to get divorced. Maria, if a party to a marriage, if one person wants to get divorced, can the other person prevent the first person from getting a divorce judgment? Can you force, in other words, can you force someone to stay in a relationship if both parties are not in agreement?
No, unfortunately, you cannot go into court and just demand that the person not be granted their divorce. It's a no-fault state in Michigan here, Joumana, and people have a right to get divorced. You will have judges that are told by parties that are contesting a divorce that, we don't have involuntary servitude anymore, and that's what that would be if they were to deny the divorce.
So it used to be that Michigan and every other state in the United States was a fault state, meaning you will not be able to get a divorce unless, even if both parties want it, unless there is fault in the, say, adultery, for example. Those laws have long changed. You said for as long as you have been working, and you've been working as early as when you were 14 years old. Your father, who is a family law attorney, you would hear your father say, sorry, if your wife wants a divorce or if your husband wants a divorce, you have to give them the divorce because we live in a no-fault state, meaning we don't care if there is fault or there is no fault. If one person in the relationship wants out, the other person has to give them that.
Yes, or the judge will force them to. One of the two things will happen.
Okay. So سؤال من الأسئلة اللي نسألنا ونحكي عنه لأنه منه يعني في عنا أوقات بيجي لعنا أشخاص الطرف الثاني عم بيطلقهم وما بدهم يتطلقوا، ما بدهم يهدموا العلاقة، ما بدهم يهدموا البيت، ما بدهم يهدموا الأسرة. فشخص بيكون مقدم بالطلاق بس الثاني عم بيحارب وما بده الطلاق. للأسف بالماضي قبل ما أقول للأسف بالماضي، يعني من أكثر من 30-40 سنة إذا مش أكثر حتى، ولاية ميشيغان مثل كل ولاية بالولايات المتحدة كانت a fault state. يعني ليقدر شخص من الشخصين يطلب الطلاق ويطلق، أو للطرفين يقدموا طلاق ويقدروا يطلقوا والقاضي يسمح لهم يطلقوا، لأنه الطلاق كان نادر جدا. كان لازم نثبت أنه في خطأ fault، ومش يلا غلطة ماتيريال، غلطة حرزانة مثلا. مثلا في لا سمح الله adultery، يعني خيانة بالعلاقة. هيدا القوانين تغيرت، صرنا هلأ للأسف بوقت بعمر إن كان بولاية ميشيغان أو بكل ولاية بالولايات المتحدة، إذا طرف من الطرفين بالعلاقة راد الطلاق، إن كان لسبب وجيه أو لسبب غير وجيه، إن كان لسبب أو بلا سبب، القاضي لازم يعطي الطلاق. هذا الشخص اللي اتصل فينا ما بده يطلق، عن جد ما بده يطلق، وفكر إنه he's contesting the divorce. You cannot contest a divorce، لأنه القاضي بده حتى لو ما تعاطفت مع الطلاق، حتى لو ما رحت على المحكمة، الطلاق بده يتم، لأنه هي القوانين. إجانا سؤال من الأستاذ حسام: Can I date while going through a divorce in Michigan؟ أستاذ حسام، لو بتجاوبنا قبل ما ماريا تجاوب على السؤال، قديه صار لك مفترق عن زوجتك وأيمت قدمت الطلاق؟ وهل dating relationship اللي حضرتك فيها كانت موجودة قبل ما أنت تفترق من زوجتك، ولا تعرفت على هالسيدة من بعد ما افترقت عن زوجتك؟ Attorney Maria Panchenko, we got a question from a gentleman who is asking if it is okay for him, and if there are laws against it, one, and if he will be adversely financially impacted, if he dates while he is in the middle of divorce. So he is going through the divorce, and he wants to know if he can date. I asked Mr. Hussam if he can follow up with, how long has he been separated, how long he's been going through the divorce, and whether this person in his life existed before the separation.
Yes, that is a loaded question. And the truth is that a lot of people do. Whether or not they should depends on the specific facts of the case, to be honest. And also, we can put this out there that...
Let's begin by asking, is there a law, I'm sorry to interrupt, is there a law against dating as soon as you leave the marital home?
Yes, if you're married, there is a law that says that you are not to commit adultery. It's still on the books, still considered a felony. However, I have never heard or seen it prosecuted.
So it is not true when we hear that as long as you left the home and you're going through your separation and you will be filing for divorce, you are a free person. That's not true. Technically speaking, there are laws on the book that say as long as you are legally married, to be with someone else is adultery. The fact that prosecutors are not prosecuting it is irrelevant, but technically there is a law.
Technically,
correct?
Yes.
Okay.
Yes, you're right, Joumana. I just have never seen it actually prosecuted before.
Well, just like adultery is a felony, but you have not seen prosecutors prosecute it either.
Never. Yeah.
Okay.
And, a lot of people do date while they're going through a divorce process. But the other side of this coin is whether or not you should, because of the specific facts of your case. Like if you have children,
yes,
how would that impact them, and how would the court view that in determining your custody and parenting time situation? If you are eligible or meet the standard test for spousal support, if that's going to impact or increase your chances of paying more spousal support or being awarded less in your property division. There are things that can be impacted by fault. Now,
Okay.
you don't have to prove fault, but they can be impacted.
So the fact, financially speaking, I'm going to translate all of this in Arabic, and then we got some additional information from Mr. Hussam. But the fact that somebody is in a relationship while going through a divorce may financially hurt them because it may go to fault and tilt the division more in the favor of the not at fault party versus the at fault party. It may become 51 division of property 49 or 60-40.
Yes, it's less common these days to see that, but it is a potential risk factor that you're jumping into if you decide to have a relationship during a divorce.
So سؤال الأستاذ حسام إذا بيقدر يخرج سيدة وهو بنص طلاق، يعني بلش الطلاق بس بعده بعيون القانون إنسان متزوج. المحامية ماريا بتقول إنه طالما الإنسان بعد ما مضي على وثيقة الطلاق يعني بعده بعيون القانون متزوج، وإذا متزوج ما بيقدر يدخل بعلاقة جسدية مع أي إنسان لأنه تعتبر زناية أو زناية، بيقولوا زناية adultery. صحيح انه هي فلني، هي جنايه، وصحيح انه بيقدر المدعي العام يقوم دعوى فيها، بس عمليا اصلا الادلتري يعني it is a crime on the book، بس ما ولا مره بنسمع انه في prosecutor قام دعوى بهذا الموضوع. وانما technically speaking هيدي تعتبر زنايه. ثانيا ممكن هيدا التصرف، هيدا السلوك يأثر مع القاضي على الأطفال، على قدرته أنه ياخد الأطفال وقديش، بالأخص إذا عرف ولاده على هيدي السيدة وبعد الشغلة جديدة وبعد الشغلة حامية وحسب أعمار الأولاد، حسب سلوكه. هيدي شغلة مهمة يمكن تأثر سلبياً على القاضي بالنسبة لقدرته يشوف الأولاد. والطريقة الثالثة fault، لأنه يعتبر adultery is fault، وكمان مرة technically للإنسان يتطلق بعده إنسان متزوج. fault يعني الغلط مثل الadultery ممكن to tip the scale in favor of the not at fault party، ممكن تساعد الطرف الآخر اللي هو مش مغلط ماديا. كيف؟ عادة بولاية ميشيغان كل شيء بينقسم 50-50، بس وقت بيكون في غلط صحيح ما عم يستعملوا كتير هيدا الارجيومنت بهالايام لانه تغيرت السوسايتي، but technically speaking ممكن المحامي تبع الوايف تطلب انه تاخد اكثر من 50% لانه هيدا الانسان he is dating يعني is committing adultery، يمكن تاخد واحدة 50% 55%. بتذكر طبيب أنا بعرفه من تقريبا 15 سنة للأسف كان عنده a history of adulterous relationship بالعلاقة، وقت اللي اجوا ليقسموا الماريتال assets زوجته أخذت 60% وهو أخذ 40%، بس هي ما كانت بس علاقة واحدة، كان عنده هو a series of adulterous relationship in the life of the marriage. So هيدا شيء عم بحكي من 20 سنة، هيدا شيء ساعد كتير زوجته at the time وقدرت حصلت على 60% as far as the division of the marital property. الأستاذ حسام كمان بيسأل أنا كنت بعلاقة مع امرأة أنا ومتزوج وهذا هو السبب اللي أنا عم أقدم طلاق، ما بنعرف إذا هاي العلاقة غير العلاقة اللي هو فيها، but at any rate Attorney Maria Panchenko, this gentleman adds that he was in a relationship with a woman while he was married, and that's the reason why he is going through the divorce. Does that change your answer as far as the children, as far as the division of property? Does that make it seems, assuming that that's not the same person, so maybe there's been a pattern here, and maybe that will tip the division of the marital property more in favor of his wife. What do you think?
Yes, I mean, obviously, of course, this would be a matter of whether or not his current spouse is going to try to utilize this information to her benefit in the divorce and in the negotiation. Some people, they don't care. They're like, okay, you found somebody else, we're going to move on. But some people, are very, very strongly affected by it. And they feel that they want to pursue that option that you were just discussing, that, how can this fault that my spouse has placed on causing this divorce help benefit me in my divorce
financially?
Yeah, so it kind of also goes to who you're working with, right? Who is the other party? Are they going to be taking that information and running with it, or are they going to say, you know what, I don't really care what you're doing in your private life anymore. I just want my divorce, and that's fine. So that's one way to look at it. But with his added information, it almost solidifies what I said. If you're starting to date mid-divorce someone new, there's more of a potential of that infecting, if you do have children, possible, issues coming up with custody. But if you are saying that you were dating someone prior to the divorce being initiated, prior to the separation, and it caused the separation or the divorce to be initiated, it is more likely in your situation that element of fault is at risk to be used against you if your current spouse wants to take that avenue and say, look, you started seeing someone else, it caused this divorce, and I believe that I would like to argue that as one of my factors for spousal support, or one of my reasons that I believe that the property settlement should be in more my favor. And, like I said, you don't see a lot of that today. It's a little bit more prevalent a few years back, but it does still happen, depending on the attorney that your spouse might hire, and depending on the desire of your spouse to utilize that information and try to see what the judge will rule as far as property division.
So, Maria, if you were representing the woman, would you, as an advocate, because you're an advocate, if she shares with you that there's been, adultery that caused the breakup of the marriage, as opposed to adultery after the separation, would you make the argument would you push for division of the property for your client greater than 50%?
I would probably start there. Yeah. I would probably start with that, as her advocate. If I'm playing devil's advocate here, and I am her attorney, yes, I would probably start the conversation with, look, this divorce was caused by this affair, and at this point, we are asking for spousal support, and we are asking for a greater division in the property. And if there were children involved, I would start advocating for that new person in the ex's life to be kind of removed from the children's line of sight for a while, and for that conversation to be eased into if it's not already happened. And that's another way it can affect the divorce.
I have seen judgments of divorce that place very specific conditions on: you cannot have anybody sleep at the house around my children, you cannot bring anybody into the house, things that are very specific about the other parent dating while the children are around. Am I correct?
Absolutely. We just finished a divorce like that. Very specific, a whole page of conditions on new partners.
Okay, share with us some of these conditions before we leave this topic.
The one, that the person cannot be introduced to the minor child until the dating relationship between the parent and the new partner has exceeded 6 months. No cohabitation for a period of at least 1 year. No overnight stays for a period of at least 6 months after that initial meet happens. There were rules in there about parental cooperation, making sure that the new partner has absolutely no authority to discipline the child, has no authority to be alone with the child. As far as using that person as a babysitter, that was out. The conditions went on for, it seems like, a really long time. They had a lot of stipulations, and in this case, Joumana, it was a case of infidelity causing a divorce. So obviously this is a very sore subject for this particular couple.
Do you have any advice to people who are listening, the Hussams of the world, in that, obviously we're not judging here, who are we to judge,
No.
but do you have any advice?
Obviously, I would seek counseling, if you can, if you've fallen in love with somebody else, you can't stop that, right? So it happens. I just think that, make sure you're listening to your attorney in your specific situation, giving all the details of your case, all the details of your relationship to your attorney, so that they can, and all the details of your property and your assets and how your children are raised, if you have children, so that your attorney can give you the best advice possible on how to either tone down the relationship based on what they're seeing coming from the other side and how far they are going to take it, or your attorney to be able to advise you going forward what the most respectful way to approach the situation is, so that you're not creating a problem for yourself in front of the judge, or creating a problem for yourself where we're going to exacerbate an already sore spot for the soon-to-be ex, so that we can get through it as amicably as possible. So my best advice is to share all details with your attorney and listen to their advice, because they're going to assess each situation for its specific facts.
Wonderful advice. If you represented the wife, you would want to advocate for more marital property, a bigger division of the marital property, and maybe spousal support. If you are representing the husband, you want to advise him about toning it down because the other side might run with it. Thank you so much, Attorney Maria Panchenko. Let's take a very quick break, and then we're going to shift gears to PPOs, what we call malicious use of a telecommunication device, what we call telephone harassment, and what we call computer harassment, and cease and desist letters.
مكاتب المحامية جومانا كيروز تتمنى لكم السلامة في ظل انتشار وباء كوفيد-19. المحامية جومانا كيروز مثلت على مدى 22 عاما ضحايا حوادث السيارات مع طاقم من المحامين ذوي الخبرة، وحصلت لموكليها على تعويضات بمئات الملايين من الدولارات. قبل أن تختار المحامي الذي سيدافع عن قضيتك، دقق في تاريخه المهني. ومع مكاتب جومانا كيروز ستنذهل بآراء مئات الموكلين وخبراتهم الإيجابية في جوجل ريفيوز. مكاتب المحامية جومانا كيروز يتحدثون لغتك العربية والكلدانية. 248-557-3645 والاستشارة مجانية. Your Rights مع المحامية جومانا كيروز.
ونرجع لمدة بعد نصف ساعة مع المحامية ماريا بانشينكو، اختصاصها في مكتبنا Family Law وكريمنال Law. مؤخرا نحن غيرنا الجدول وصرنا بنستقبلها نهار الثلاثاء، بس إجمالا من وقت إلى آخر بيكون عندها التزام نهار الثلاثاء، فبنقلب الجدول ونستقبلها نهار الجمعة. بعد عنا نص ساعة، وعلى فكرة أي شخص بحب يتصل فينا أو يمكن the preferred method بقضايا family law, criminal law, bankruptcy هي أكثر the radio WhatsApp، هو الرقم 313-327-7074، هو الراديو واتساب نمبر ليلي بحب anonymously يبعث لنا مسج. وطبعا يعني غيروا اساميكم ما في مشكل بتاتا، بس بنستعمل اسم هيك as an example لا اكثر ولا اقل. اللي بحب يبعث لنا مسج على 313-327-7074 واللي هو الراديو واتساب. Attorney Maria Panchenko, it appears that we've seen a rise lately in people getting PPOs against them, or people wanting to file PPOs against others.
Yes, that is absolutely true. We have had a lot of those kind of calls.
Tell us more about it.
Well, I think that, as we have discussed in the past, we've had a lot of rise in domestic violence during the COVID-19 crisis and the lockdown here in Michigan. And I think that this is a natural follow-up to that. Those cases may now be resolved, and the person who was victimized may still feel threatened, or, the continued threats or perhaps other family members getting involved and starting to harass the victim or the perpetrator. And, so there's a lot of different reasons why we might be seeing the rise. But also, I think that it could potentially be a situation where filing for a PPO used to be as simple as going into the courthouse and doing it yourself. Now you can't go into the courthouse. So I think, that extra added confusion of how to do it without an attorney, with the court being closed, has been another reason why attorneys are starting to see more PPOs, because of the inability to have access to the court as people used to file their own. So I think that we see a lot of different reasons why it's on the rise.
Yes, I think you are totally right. Of course, you are right. Yes, you practice, but yes, it used to be that you don't really need a lawyer. You go to the court and you make a showing that, and we're gonna talk about what you have to show to get a PPO. But you'd walk in and talk to somebody, show them some evidence, and file a PPO, and then serve it on the other side, who now has a chance to defend herself or himself, because you don't want the PPO to be an illegitimate and a violation of somebody else's due process. But now that the court is closed, you cannot physically walk to the court, and trying to do it online may be confusing for people. And I don't know, Maria, but I have noticed that people have changed after COVID-19.
Yeah,
you're
right.
I don't have a very good impression of how COVID-19 has changed a lot of people. I've found people to be more short-tempered, more impatient. Money is an issue. They're impatient with money, when their money will come in, and so forth. And I don't know. There is a lot of the human touch, and it's coming across in the interactions between human beings. At least that is my impression. I also personally. Go ahead, please.
Oh, I was just going to say, I completely agree with you on all ends of what you said. I'm seeing it in all people as well. And, people have changed a lot since this has happened, and everybody's on edge. I feel like to some degree or another, if you're somebody who is a more, like we've said in the past, a person that, might lose their temper, that this has just been a really hard time for everybody. And like you've always said before, this is the best time to walk away, is tensions are high in this world right now for a lot of reasons.
Indeed. And I personally believe, and I know you agree with me, and everybody will agree with me, is the rise in social media, where you can write about somebody, you can put a picture about somebody, you can hurt them, you can harass them, you can annoy them, you can try to talk bad about them, you can try to ruin their reputation. I think it's really giving a rise for people wanting to explore what their options are to stop other people from ruining their reputation and talking bad about them.
Right.
That it is as strong as trying to file a PPO, and that's not easy to do, because you really need to make a showing that your life is in danger or your property is in imminent danger. But there have been other statutes, laws on the books. By the way, this law that we talked about 3 or 4 times before has been on the books since, it seems, 1969. And it's getting used a lot lately, and that's the 750.540E, malicious use of a telecommunication device. It's been on the books since 1970. So what's that, 50 years? But
yeah.
But we're starting to see an increased use by prosecutors to charge people who are annoying other people, who are calling them, leaving them nasty messages, maybe, going online and talking bad about them and so forth. And you need a much smaller showing to get a prosecutor to charge somebody with malicious use of a telecommunication device than it is to get a PPO. And I know I'm all over the place. Can we please tell the listeners, what do you need to show to get a personal protection order against?
Well, to file the personal protection order, you're going to need to file some kind of immediate, or not immediate, but you're going to have to show some kind of reason why you feel that you are terrorized or frightened, intimidated in some way, where you feel that you have threat of harm coming to you by this person that you're trying to get the PPO against. if you want to prohibit this behavior from happening, you're going to have at least 2 instances of threatening behavior that you can articulate in evidence to the judge that you're asking to sign the PPO. It's not as low of a threshold as something like what you were just discussing, which is the malicious use of telecommunication device, which all you really have to show is that you were annoyed, and the police are able to utilize that statute to charge you with that misdemeanor.
So to get a PPO against somebody, you have to show that your life or your property is in danger, and in imminent danger, not in danger 6 months from now, but in imminent danger, meaning you are likely any minute, any second, any day to be in harm's way, whether you yourself or whether your property, whether it's your car or your home or whatever it is. And you're saying show at least 2 examples or instances of how you felt, or you can make a showing that what happened made you feel that you are in imminent, meaning anytime now, threat of immediate harm to yourself or to your property.
Yes, you're going to have to show, if you're trying to prohibit that kind of behavior, yes, you're going to have, unless there's been one profound incident that has taken place, somebody came after you with a knife and you're able to, put that police report as an attachment, that would be one instance where obviously you're in immediate danger, like life-threatening harm. But if you have a situation where somebody is maybe just appearing at your work uninvited just to intimidate you and threaten you, and you want to prohibit that type of behavior, you're going to have to show that this is a continuing pattern, that it didn't just happen one time. Because if it's only a one-time instance, the PPO is kind of unnecessary, right? Because it's never going to happen again. It's just a one-time instance. If somebody is doing it repeatedly, that's when you're looking for that PPO to stop the stalking, intimidating, threatening behavior. But you need to be able to prove that that's what's going on.
Okay, so very quickly, talking bad about somebody does not give you grounds for PPO, correct?
Correct.
Okay, very good. So by the way, we got a question from Tima about how long is a PPO? I think the question meant differently. I'm going to tell you what her question says. How long does a PPO stay on my record? So let's assume, okay, I think if she has been served with a PPO, how long does it stay? First of all, PPOs don't last forever. You have to go renew them. I think they're good for 6 months, maybe.
They're all different, actually. It's up to the judge. Yeah, it's up to the judge. You could have 1 year, 3 months. The judge will make that determination at the signing of the order based on the circumstances.
And then you can go and renew it if you show an ongoing showing of imminent threat of immediate harm to you or your property.
Yes, the person who asked for the PPO can go and ask for it to be extended, the length of time extended of the order.
Okay.
But they have to show the reason. I mean, if the behavior has ceased because of the PPO, and the order would naturally end. But if there's been continued issues, then obviously they're going to want to go ahead and ask for that extension.
Okay. What if you were served with a PPO? How long does it stay on your public record? Will it be on your public record? Will it be known to your credit scoring companies, Equifax, Experian, and TransUnion as a criminal record?
But it's not a criminal record because you're not charged with crime, right? So what it is that it shows up on your lien. And anybody who has access to lien or can run your background check would be able to see that for the length of time that it's in effect.
So law enforcement and courts will see that. They will always see that, even after it stopped being in effect. What if you're applying to an employer who does a criminal background check?
It would depend on what background check company and service that they're using, right? If they're only using something that is only going to show criminal convictions and that's all they're interested in, it wouldn't show as a criminal conviction. But if they're doing a full state, a full state record, it's going to show something is in effect there while it's in effect. If it's not in effect any longer, they're not going to have access to it forever.
If somebody does a freedom of information on you, a FOIA on you, will the fact that you have a PPO appear?
When you do a FOIA request, you have to specifically go to the police station that it would have come out of. There's no open FOIA to just say, I would like to know everything about this person. Here's the FOIA. You would have to go to the specific police station. Let's say hypothetically, the incident that caused the PPO to get issued happened out of the Dearborn courts, Dearborn Police Department. And you knew that, and you wanted the police report, you could do a Freedom of Information Act request to get a copy of that police report, but it's not going to say, oh, there's also a PPO out of the Wayne County Circuit Court, which is where you have to go in order to get the PPO in the Circuit Court.
Okay. All right. Thank you very much, Maria. I want to remind the listeners that we are talking about criminal law and family law today, and the discussion right now is about PPOs and about other charges that prosecutors are increasingly using against people who are trying to annoy, to intimidate, to harass, to frighten, to terrorize, to disturb the peace and quiet of another person. And very specifically, we're talking about a law that has been on the books since 1969, and we're finding increasingly that prosecutors in today's age, in today's social media age, in today's telecommunication devices age, everybody has a phone, everybody has a mobile phone and so forth. We're seeing that prosecutors, in order to keep the peace between citizens, are sometimes resorting to charging people who are, annoying, harassing, intimidating, frightening, leaving annoying messages, even calling and hanging up repeatedly and so forth, with the charges. Not PPOs, because for a PPO, you have to show that your life is in imminent danger or your property is in imminent danger, but with charges that are like a malicious use of a telecommunication device, which is a misdemeanor, by the way, or a telephone harassment. There are a lot of cities that have city ordinances where one person, if they're using the phone, can be charged with telephone harassment, which is also a misdemeanor, or computer harassment, and although they are misdemeanors, there is always the possibility of jail, especially if there is a record of that. But by the time you are done hiring a lawyer, and we've had some of these cases in the office, people charged with malicious use of a telecommunication device. By the time you are done paying a lawyer, going through all the heartache and paying the court fines and fees, you're several thousands out, and it was not a good situation for you. And then it is on your record. By the way, speaking of PPOs, it's not a charge, I get that, but if you want to purge your criminal record, can you purge the existence of a PPO against you at some point?
Well, you can motion to terminate the PPO so that it's no longer in existence. But as long as the judge has the order in effect and continues to agree that the order should stay in effect, there's no way to seal that from being found until the actual PPO is terminated or ceases naturally from the when it extinguishes on the order. It will be able to be seen that there's a PPO in effect as long as the judge says that it's in effect.
Okay, very good. Rami, if we can take another very quick break and we will continue.
في ظل ادعاءات التحرش الجنسي الموجهة ضد جامعة يونيفرسيتي اوف ميشيغان والدكتور روبرت أندرسون، يمثل مكتب المحامية جومانا كيروز العديد من ضحايا هذه التحرشات. مكتب المحامية جومانا كيروز حصل على تعويضات كبيرة في قضايا مماثلة تراوحت قيمتها ما بين 900,000 إلى 3.3 مليون دولار. إذ كنت تعتقدين أنك من ضحايا التحرش الجنسي في جامعة يونيفرسيتي اوف ميشيغان أو من قبل الدكتور روبرت أندرسون، اتصل الآن بمكتب المحامية جومانا كيروز 1866 Your Rights 248-557-3645 والاستشارة مجانية. Your Rights مع المحامية جومانا كيروز. عودة إلى برنامج يور رايت مع المحامية جمانة كيروز، وأرقام الهواتف في الاستوديو 313-769-6666 519-256-1023. جمانة نرجع لك.
بكل سامعين بعد عنا ربع ساعة عم نتكلم، لباقي الربع ساعة رح نتكلم عن التهم اللي للأسف بعض الأشخاص عم ببرشوا يتعرضوا لها من قبل البروسيكيوتر، اللي هن malicious use of a telecommunication device. هيدي وحدة. تاني وحدة telephone harassment. ثالث وحدة computer harassment إلى آخره. وكمان happy weekend, happy Labor Day weekend للجميع، وهالنهار الجميل على الجميع يا رب. Attorney Maria Panchenko, I am looking at the language of malicious use of the law, the Michigan compiled law. That's specifically for anybody who wants to look it up. Michigan compiled law 750.540E, E as an egg. Again, 750.540E. It is so liberal. It is so easy to get charged under this one. And I will read it, a person is guilty of a misdemeanor who maliciously uses, and by the way, maliciously does not really mean maliciously, who uses any device provided by a telecommunications service provider. So that would be a phone, that would be an iPad, that would be a tablet, that would be a computer. Any of those is a service provided by a telecommunications service provider, correct?
Correct.
And the intent, they say maliciously, but you really can be charged with it for a lot less than that, because they say if you intend to terrorize somebody, if you intend to frighten somebody, scare someone, if you intend to intimidate someone, if you intend to threaten someone. Now that can be also grounds for a PPO if your threat is immediate to your person or to your property. If you intend to harass someone, if you intend to molest someone, if you intend to annoy someone, or if you intend to disturb the peace and the quiet of another person. If you intend to do any of those, they give other examples. If you use vulgar, indecent, obscene, or offensive language, or if you suggest any lewd act in the course of a conversation, if you repeatedly initiate a phone call without speaking and you deliberately hang up or break the telephone connection, if you make an unsolicited commercial call between the hours of 9 p.m. and 9 a.m., if you use a telecommunication service in a repetitive manner, so you keep calling, trying to see if there is anything else, even if you report falsely through the use of one of those devices that a person has been injured or suffered death or been the victim of a crime or taken ill. All of these are examples. Even if you threaten physical harm or damage to a property, even if it's not imminent, even if it doesn't rise to the level of a PPO, you will be charged under the malicious use of a telecommunication device, correct?
That's correct.
Okay.
It's a very exhaustive and very broad list of things that, this really is a catch-all for anyone that is simply bothering another person using a phone or, like you said, a tablet or anything that can get a signal out.
Yes, anything that has a signal. Yes, that's a good way to put it. A telecommunication device is using anything that has a signal. So that can be a phone, that can be a laptop, that can be a computer, that can be an iPad, that can be a mobile phone. We want to tell our listeners that we're seeing those cases happen. And so don't think you are immune. Just make sure that you do not put yourself in a position where you will be accused and you will be charged with the misdemeanor of annoying somebody, of irritating somebody, of harassing somebody, of scaring somebody. of intimidating somebody, of calling repeatedly and hanging up, or calling and leaving messages using vulgar, indecent, obscene, or even just offensive language, or suggesting a lewd act, suggesting an inappropriate sexual act. That's what this means. Repeatedly using the phone and hanging up without speaking. All of these, they give rise, and we have seen them in our office, give rise to people being charged. By the time you are charged and you get through and you pay the lawyer and you pay the court fines, the court fees, and you have it now on your record, it's really not worth it. There are laws, because in today's social media, in today's increasing use of technology, there has to be laws to protect people from being harassed all the time. So those laws are on. Yes, go ahead, Maria.
No, that's what I just said. Yes, you're right. There has to be these type of law. It's frustrating being it so overbroad, because you're having a heated argument with someone, and you use vulgar language. People are human. Sometimes it happens. If the conversation remains this way, it just kind of almost opens the door for a little bit too much, in my opinion. But the fact still remained is that it is a law, and it has to be in effect, because for the people that are utilizing their phones to harass and intimidate, we have to have something in place. I just think that sometimes it can be that this law could possibly be seen as overbroad, and can touch so many things. Just like you said, if you're simply annoying to someone, and it's a subjective thing. How are you to see if whether or not somebody this might annoy one person, but it's not annoying the other person? It's a little bit overbroad, in my opinion, but I understand the reason why it needs to be there for those who are victimized, truly victimized.
And I will say the cases we have seen and heard about, it's not just like one instance. You can't also abuse the law and say, oh, he annoyed me through the phone or through a telecommunication device. I am going to go file a police report so that the prosecutor files a misdemeanor charge of malicious. You have to convince the police officer. You cannot abuse that either. For example, I remember one of the cases that we had here arising at Rochester Hill. That person, our client, was charged. She was repeatedly calling her ex and hanging up. She didn't call once or twice. She repeatedly did it. She called and hung up about 15 or 20 times. Well, that's 15 or 20 times too many. That's 14 or 19 times too many. So it is much easier to convince the police officer when you show, what's on your phone. It's much easier to convince a police officer that this person needs to be charged versus once or twice. So, you're right, it is subjective, and you have to convince the police officer, that you've been the victim of this crime, MCL 750.54OE, for the officer to write up a police report and send it to the prosecutor. Maria?
Yes, sir. Yes, you're correct. I'm sorry, the phone was having trouble connecting my voice.
Not a problem. With the 6 minutes remaining, I want to talk about another charge that people who are abusing others by using the phone. This one uses the phone. So the malicious use of a telecommunication device applies to phones, because like you said, you accurately described it, applies to anything that has a signal. This charge is telephone harassment, and we'll find it in a lot of city ordinances across the state. Tell us about telephone harassment, and is it a misdemeanor?
Yes, it's going to be a misdemeanor, and obviously it's going to, like you said, it's going to vary from place to place across the state, depending on how they define it. But the general idea is it's very similar to what we're reading here in the malicious use of the telecommunications device language from the state's statute. But there can be some variances. Some cities that I have seen use the telephone harassment city ordinance of their own. it is written into their ordinance that there is a minimum number of telephone calls that need to be made unless the telephone call is threatening in nature. Then I've seen where the city ordinance has, it's very broad, just like this, the state's statute, that they utilize this language: harass, annoy, molest, and they will take evidence such as, the hang-ups that you were discussing before, how many times you hang up the phone. So you're going to see a lot of variances, but for the purpose of what we're talking about today, it's the general idea that the cities are going to start cracking down and have been cracking down on people who are utilizing all of this technology to bother other people. And whether it's called telephone harassment or malicious use of a telecommunications device or just simple harassment, you need to make sure that you don't act in such a way that you are going to be charged with a misdemeanor. And the malicious use of a telecommunication device from the state is a 6-month misdemeanor.
The telephone harassment is a 6 month?
No, the malicious use of a telecommunications device.
You have the possibility of jail up to 6 months.
Yes, and some of the city statutes are for 90 days or 93 days. But if you're charged by the state, you could get 180 days in jail.
What Maria means is that the malicious use of a telecommunication device is a state law, but a lot of cities have also adopted it. So it is a law on a state level, and it's a law at a city level, like in Rochester or Rochester Hills. I don't know if they charge it under the city or they charge it under the state, but the state sometimes is more stringent and carries, the state is more stringent and carries 6 months. Sometimes the city may carry less or may carry just as much. Can you be charged with more than one of those? Can you be charged with malicious use of a telecommunication device and telephone harassment?
It's possible that if the facts are providing that you utilize the tablet and on one occasion and then use your phone on another occasion, that you could be charged with both, or if it's two separate individuals that you're being accused of harassing. So it is a possibility that you could be charged with more than one.
Okay, and in the 3 minutes remaining, can you tell us what computer harassment means? Is that also a misdemeanor charge?
Depending on the specific facts of what you're actually saying on the computer, it could be a felony, could be a computer crime case that goes to a felony level, utilizing a computer to commit a crime. But if you're harassing somebody using a computer, it's usually what you will see is the Facebook, different social media sites, jumping on the computer and utilizing emailing and things of that nature.
Okay, very good. So I think the advice we're giving here today with the less than 1 minute remaining is make sure that your behavior doesn't rise to the level of being prone to being charged with malicious use of a telecommunication device, telephone harassment, computer harassment, or even PPO. On the flip side of that, if you are suffering, if you are in imminent threat of an imminent harm to you or your property, you can file a PPO, or you can be, charging somebody, filing a police report to charge them and get them to stop with malicious use of a telecommunication device, telephone harassment, or computer harassment. Happy birthday weekend to everybody. I hope it's a safe weekend to everybody. Attorney Maria Panchenko, thank you so very much. We'll talk to you next day, Rami. Thank you very much.